Hello friends, we had a massive success in our last webinar. This was our 5th webinar on PatBiz systems for patenting, how to monetize on patenting, how to make sure that you can maximize your income from patents. So thank you for being a part of this webinar, and also I appreciate your presence and your questions that you're asking. So I'm going to answer all your questions in this video. And the people who have not yet joined this webinar, don't forget to join it next time. I will answer all the common questions that I have received during this webinar and after this webinar. So first question was regarding patentability search. Is it really important to do a patentability search? Yes, it is important to do a patentability search, because if you fail to get a patent in future, you will be spending a lot of money and those investment will be wasted. Okay, it is very important. Either you do it on your own or hire a consultant, hire an expert and get an opinion from him. Okay, getting an opinion from an expert will definitely resolve most of your queries. Doing on your own, you may not be able to cite relevant citations which are close to your invention, but they are not using similar terminology, similar nomenclature, or nomenclature that you don't know that can be used in patents. So those kind of patents you may miss. So that is the reason you have to work with experts. Second reason, finding a novelty or giving a judgment on novelty is very easy. One-on-one there is a match, both the inventions are same, novelty is gone. If you think that both the inventions are similar, in that case novelty is yes. Just make a note of it. It has novelty. And the next question arises is whether your invention has inventive step or not, whether your invention is obvious to a person skilled in an art or not. Okay, so this is a little tricky question where we need to cite some documentation which are used or which are having similar documentation which can prove that the adaptation of the technology, the way you have modified the technology, is very obvious, and you should not get a patent based on those citations. To get this judgment, it is little difficult. So that is the reason I'm asking you to work with experts. Don't do it on your own. Otherwise, after 2 years or 3 years, if you found that after making investments in multiple countries or a single country at least, you found that your invention is not granted a patent, the entire money that you have invested on patenting will be wasted. Okay, specifically in India, you will be spending somewhere around 1.5 lakh rupees on patenting. If you file a patent application in US, you will be spending somewhere around 2,000 to 6,000 USD till you get a patent certificate. When it comes to Europe, European Union, there is a union in Europe. It's very expensive. The advantage is you can file a patent through an union. That's one advantage, but it is very expensive. Around $6,000 is just a filing fees. Prosecution, examination, and other fees are on a very higher side. I hope this helps. Don't file a patent application without doing a patentability search. You can file a provisional application, then conduct a patentability search, and then go for complete specification. That is non-provisional application. But before filing a complete specification or a complete application, non-provisional application, do conduct a patentability search, which will give you a fair idea whether your investment will go in right direction or not. I hope this helps. Thank you. So the next question that we are getting is how to file a patent application online. So visit website ipindia.nic.in. On that website, go to the patent section. On that section, you will find comprehensive e-filing. Links I will be sharing. Okay, on that, first you have to create your own account. For creating your own account as an inventor, you need class 3 digital certificate, class 3 digital signature. Without that, as if now, you cannot create an account. So government is planning to discard this requirement, but as if now it is a requirement. Once you register yourself with there, so you can file patent application on your own. This is ipindia.nic.in website. So they have changed the URL now. It's ipindia.gov.in. Here you can create your own account as a new user. So you can be a natural person, organization, a legal entity, small entity, whatever qualifies. Next, you can select digital signature or electronic signatures and fill in the details. Then you can register yourself. Thank you. So there are various options that are available. So it's a very simple process. You have to fill the online form first, click the relevant bullet points, upload your documents, sign it digitally, and then make the payment for filing. After creating your account, you can log in, choose a new application if it's provisional. Or direct complete specification. If you're filing provisional to complete, you can choose form 2. Fill all the details over here, upload the documents, then go to the form section, sign it digitally, and then you will be proceeded ahead to the payment section. So you can do the payment. Receipt would be generated online, and additionally a receipt would be sent by the Indian Patent Office with applicant's name, title, and other details. So it's a simple process. If you have time, you can do it on your own. Otherwise, the consultants will do it at a very reasonable cost. Filing a patent application won't cost you much. So mostly around 5 to 10,000 rupees people may charge, because they also need to follow up with the patent office after filing this patent application. Okay, I hope this helps you. The next question is where to file a patent application. So this question has been answered by me several times. So again, I'm answering this question. Wherever you are able to generate money in those countries only, you should file a patent. Otherwise, it's waste of your money. Okay, filing a patent application in multiple countries where you don't have a business is literally wasting your investments, wasting your money. Okay, choose a country. If you think that you have a marketplace in US, so choose only US. Okay, if you are an Indian national, in that case you need a permission from Indian government that this is my invention, which is not related to any crucial technology, defense related technology, nuclear technology. So I need a permission to file this patent application in other countries. This Indian Patent Office within 21 days will issue a written permission. Without that permission, don't file a patent application in other countries. Another way is file a patent application first in India, either provisional application or a complete specification, whichever you think you can. After 6 weeks, file the same application in multiple countries, claiming the priority of Indian application. So in that case, you don't need to take any permissions from the Indian government, but you will be investing on filing cost. So anyways, you have to draft a patent application, correct? You will be drafting a patent application even if you are filing it in other country like US. Okay, so I hope this helps. Next is a very interesting question actually. If I file a patent application in India, whether someone in other country, for example, in United States, copy my invention? The answer is yes. If you have a patent application in India, no one can manufacture, sell, or import the infringing product in India. Which means if they are importing, you are eligible to take legal action. Government is not going to take any legal action on its own. You have to take it. If you find someone is importing similar product in India, you have a patent in India, you think that product is infringing your patent, you have to initiate legal action. No one is going to stop on your behalf. Okay. Similarly, if you have a granted patent in US and someone is manufacturing the product in India and exporting the same item in US, you can take legal action in US because you have a valid patent in US. Other way around, they will have a freedom to operate in case there are no other infringing patents. If there are no other infringing patents, the person who is copying your technology will have freedom to operate. You cannot go into other countries and take legal action in case you don't have patent in that particular country. Okay, so another question arises, can I copy a product that is already sold in US, which has also been patented in US, but there is no patent in India? The answer would be yes, if there are no other patents which are infringing this product. So it's better to conduct a freedom to operate search. This will give you an understanding whether there are other manufacturers who have patent on this particular product or not. Okay, might be that particular person may not have a patent in India, but you cannot negate a possibility that there may be some Indian companies who have filed some patents on the similar domain which you may infringe. So conducting a freedom to operate search and launching a product is the easiest way to implement something that is patented somewhere else. Just make sure that you are not replicating the product, you are using the technology, but it should not be a dicto product. Change the dimension, change the orientation. So whatever you can change to make it sure that it is distinct, it looks distinct, you should do it, and then you can manufacture and sell it. Why to make it distinct? Because there is a possibility that there may be a design registration in India or any other country. There may be issues with respect to copyright as well, because for creating a product you need engineering drawings. To launch a product in the market you need images of that particular product, and if the images look same, maybe there may be a copyright violation as well. So just to avoid this, change the look and feel, dimensions, and the orientation of the product, and you can do it if you have freedom to operate. I hope this helps you. So next is design and patent. So how to choose between design registration or design patent and a utility patent? The simple answer is, if you have a new technology, if it is solving some technical problem, then it can be filed as a utility application, normal patent application. If the product does not have new technical advantage, if it is the same product packed in a different way, if it looks different but the technology is same, it is solving the same problem, in that case you are not eligible to file a utility patent. Rather, I can say, if you have filed a utility patent, there are possibilities that it may be rejected. So if you have something which is only aesthetically new, look wise new, which is new look wise, in that case you should only file design registration. So it has its own advantage. So you can always file a design patent as well as utility patent for the same product. Design for the aesthetics, external aesthetics, and utility for the technology going inside this product. I hope this helps you. So next question is regarding fundings. I don't have a lot of fundings, but I still want to file a patent. How can I do it? So split your spending into multiple stages. That definitely you can do, but you cannot avoid those fund requirements actually. It's little difficult to avoid or minimize it. If you minimize, your quality of your patent may reduce, so that is not recommended. So what you can do is you can file a provisional application first. Whether it is India or US, file a provisional application. So you will get 12 months of time to file a complete specification. So here you are splitting the expenditure into two parts. Initial cost is very less. Provisional is not costing much. Okay, so you get 12 months of time, utilize that time, file a complete specification or non-provisional application, file that patent application in that particular country, then file a PCT application if you think that you have a global market. So PCT will again give you a breathing time of 18 months. So from the date of provisional, you will get 30 months to file the same patent application in multiple countries. That is the advantage of PCT application. So this is how you can distribute your expenditures. But you cannot avoid this expenditure. Just make a note of it. You cannot avoid this expenditure. If you start reducing your expenditures, the only tool that you have to take legal action against others, if that is a weak document, in that won't be good in future. So that is not what you are expecting, right? So you want to take legal action against the potential infringers. You want to license it out to the potential infringers. You have to stop your competitors from doing manufacturing similar products. And if your patent document is weak, you won't be able to do it. Definitely your technology is good, it can sell on its own, but the competition that patents are supposed to reduce If that is not happening, then it is not recommended to reduce the cost. So think wisely on that, and accordingly you can split your expenditures. So next question is with respect to copywriting of the book. There is a separate IPR class that we are taking, in which we are conducting in detail understanding of patents, trademarks, copyright, design registration, trade secret, plant variety protection, even other agreements that are required for any business. Okay, so you can attend that class. So just to give you a brief answer, there is no mandatory requirement to file a copyright application. From the day it is published, you have protection on that. But if you want to take a legal action against some other infringer, in that case you have to prove that you are the first person to write this book. So in case that may happen in future, you need a valid certificate with you that I have a copyright registration with me. If you don't have, still you can file a case, but first court has to investigate who is the original author and who has published it first. So the person who has published the document or the book first will deserve to get a copyright. The other person may not get it. So that is the reason copyright filing is important, in case you think there is a possibility of litigation in future. Okay, otherwise most of the people don't file a copyright application. Just you need a valid date of publication which is authentic, which can be validated in the court. So next is with respect to Vastu-Shastra. We have been getting participants from Vastu-Shastra domain from our first class itself. Vastu domain is a little tricky when it comes to patenting, but you cannot negate patenting in Vastu-Shastra. If you are creating something aesthetically new, and if you are able to prove the change in energies, definitely you can try on patenting it. The next thing that is surely applicable is if you have some unique product with you, okay, which is not a traditional one, which is not a product which was known earlier, you are just reducing the size and dimensions. If no, not that. If you are creating something unique, then definitely you can think about design registration. Design registration, when it comes to a product, definitely it's applicable. So apart from that, changing the energy of the room, little difficult to prove scientifically that there is a change in the energy levels by putting something somewhere there, but I assume that those things fall under traditional knowledge. If you are able to prove that this is not falling under traditional knowledge and this is the effect, technical effect means it is solving some of my problems. If you are able to prove that, definitely you can think of filing a patent application for that. In India, as we know Vastu-Shastra as our traditional knowledge, Indian people may rethink on giving utility patent. But design, yes, if it is novel design, not a scaled down miniature replica of some known products. I hope this helps you. And the people who have not yet joined this webinar, don't forget to join it next time. I hope you like this. If you have any comments on this, comment in the comment box. I would be really happy to know your thoughts on this. And also let me know any topic that are of your interest. I would like to make videos on those topics as well. So keep inventing, keep investing, and keep earning tremendously. See you soon.